Welcome to Suits on Suits in Shirts. We'll get to that later.
Yeah.
This is the show where Jared and I, two practicing lawyers and brothers, break down the show Suits. If you're interested in the law, culture of law, or just like Suits, this is the show for you.
On today's episode, we're going to be talking about a number of legal topics, class actions, negligence claims, talking to represented parties if you're a lawyer, and private investigators. Stick around to find out more. Before we dive in, should we talk about our change of attire? We had two strong episodes before we completely threw it to the winds. I even showed up.
And then we both agreed that the jackets were just, it was too much cosplay.
Yeah. Well, I'll just say this. I was not chafed by the outfit, but I am chafed by your decision.
We both agreed. This is not a one-sided decision.
Just because your blazer does not look as good as my blazer doesn't mean we need to change.
Look, we both decided we wanted to be casual, comfortable. We're either going to wear whatever the hell we want to wear, or we're going to wear suits.
That
was my decision.
We both know that Quinn
as a group.
We both know that Quinn's just a little less professional than me.
At home in a suit. At home, well, that's not true.
I wear a suit every day. I wear a suit to work. I wear a suit to bed. I wear suits to suits on suits.
I will not wear a blazer and pretend to be a professor, despite having taught a class.
Yeah. Professor Mayberry. No longer stolen valor. Give it to me.
Yeah.
So to kick it off, let's talk about the skeleton of the show. This is going to be the class action case that Harvey takes on against the oil company. Before we dive into kind of the legal analysis, I think it'd be helpful to give everyone the background of the facts.
Yeah, so to set this up a little bit, it's Harvey and Pearson Hardman representing 200 plaintiffs against Americo Petroleum, who failed to cap an oil well that was converted into a high school.
So it's like the high school was built on top of the oil well.
Exactly.
Got it.
And as a result of this failure to properly cap the oil well, these 200 plaintiffs have developed cancer and several have died.
It's the toxins have somehow leached into their environment.
Claim is being brought as a class action.
Yep.
Before we dive into the underlying claim and the negligence involved here, let's talk about the difference between mass torts and class actions.
Yeah, I think that'd be super helpful because oftentimes people just talk about these incidents, think Aaron Brockovich, and they just call them toxic torts. But the actual procedure, I think, would be helpful for people to understand.
Yeah, I also think that anytime you have a number of plaintiffs who have suffered, generally speaking, the same type of harm or have suffered even different types of harm, but as a result of the same action, it's often referred to as a class action.
Yep.
That's not necessarily the case. So this case is being brought as a class action when in reality it would probably be brought as a mass tort claim.
Great. Well, I think with that, maybe like break down the two differences so we can talk about why it would.
Yeah, exactly. Yeah. So to bring a class action under Federal Rules of Civil Procedure, Rule 23, you have to meet 4 requirements. 1, the class is so numerous that joinder of all members is impracticable.
Yep.
So basically, there's a lot of people involved.
Totally.
2, there are questions of law or fact common to the class.
Yep.
3, the claims or defenses of the representative parties are typical of the claims or defenses of the class. And we're going to get into that more here in just a moment.
Yeah, that'll be helpful.
And 4, the representative parties will fairly and adequately protect the interest of the class. So then juxtaposed to class actions, we have mass tort claims.
Yep.
Those are often brought through this mechanism called multi-district litigation. And that's where similar cases are brought together and grouped together to be decided in a single court, but they retain their status as separate lawsuits.
Yeah, so you may be deciding a particular portion of the claim in the singular court, say whether or not negligence had occurred, and then you separate them out again to determine damages if those are all disparate.
There are these efficiencies where the similarities are grouped together and there can be a decision on those similar issues.
Yeah.
But it's not a single claim.
Yes, it's judicial efficiency.
Yeah. In a class action, we effectively have a single claim. And then class actions, just to make this slightly more complicated, can then be grouped into separate classes,
Subclasses.
but the class is being brought as a single claim.
Got it. Okay. That's a helpful distinction.
The reason it's relevant in this episode is the damages were so disparate.
Yeah.
They're so different. So we have death, we have stomach cancer, we have brain cancer.
Totally.
And then it seems like, some of these plaintiffs are walking around, living their lives. They have this horrible diagnosis, and it's going to impact them for their whole lives.
Totally.
But it's very different if you can, effectively live your life for the next 15 years versus somebody who dropped dead 5 years ago.
Yeah, exactly. With dependents and...
Absolutely. Yeah. And so the damages are just going to be massively different in a case like this. Finally, you only have 200 plaintiffs. Yeah. So while that's a lot of plaintiffs...
Yeah, it sounds like a lot.
It sounds like a lot. And it is a lot of plaintiffs. And you could have a class action with 200 class members. But it's a number that isn't so large that it makes bringing the claims individually impracticable.
Yep.
To the point that it would necessarily meet the requirements of Rule 23. It might not. Again, the bigger issue is the damages are so disparate and so different between these individual plaintiffs that you're going to have a hard time bringing that as a class action. And in fact, you wouldn't want to bring it as a class action.
Yeah, I was going to say, if I'm a plaintiff, I probably wouldn't, because I would say my facts and circumstances are very different. I want to express those when I'm talking about damages.
So I said we'd return to point 3 of Rule 23.
Yeah.
The claims or defenses of the representative parties are typical of the claims or defenses of the class. So we have Kenny Verdasco as the class representative here, and his claim is, while similar in a lot of ways, is ultimately probably not fairly representative of the class. He developed lung cancer.
Yeah, is it safe to say, colloquially, or whenever I'm talking to someone else and I hear a toxin causes cancer, I think to myself, oh, like that's a linear line, right? But I guess the thought here is lung cancer isn't the same as pancreatic cancer, isn't the same as brain cancer, isn't the same in the legal setting. That you need to be very specific.
Yeah, so if you have a smoker who develops lung cancer, then a class representative who has lung cancer is going to be representative of the class.
Yep.
But there are massively different outcomes from developing lung cancer versus pancreatic cancer versus brain cancer.
Yeah, and what are the causes, right? Like,
yeah,
because you got to prove that in each case.
Exactly. So without diving into too much more detail, those are some of the reasons this would be brought as a mass tort, multi-district litigation, more likely than not, as opposed to a class action in real life.
Yeah, that makes sense. It's clear with 200 people, they're going to try, if they can, to create some judicial efficiencies by combining the claims in some way that makes sense. But I think what I'm hearing from you is the class action isn't the most efficient manner in this particular case because there are too many facts that are disparate. Not
only is it not the most efficient, but they would have a really hard time getting the class certified, which is something you have to do to move forward with the class action claim. The defense would have a great defense against the plaintiffs bringing this as a class action, and the plaintiffs themselves, or rather the plaintiffs' attorneys, probably wouldn't want to bring it as a class action in the first place. I guess moving forward, let's break down the underlying claim.
Yeah.
So they're bringing a negligence claim, whether it's class action or mass tort. The elements that they're going to really need to prove here are the elements of a negligence claim. Can you kind of walk us through that?
Yeah, absolutely. So this is kind of what I would call the substantive law of this claim. Negligence is a law that is very old, and probably I would say a majority of plaintiffs' cases are brought as negligence claims, or at least one of the claims they're bringing as a negligence claim.
The vast majority.
Yeah. This does a lot of work in the world of torts, and so negligence is broken down into kind of 4 elements, with one of the elements having a 2-part sub-element.
Yep.
So we have duty, which is, do you have an obligation to the defendant in any kind of way? The second one is breach, meaning that you breached that duty that you had to the defendant. And the third is, and this is the one that has the subparts, the third is cause. So it's saying your breach of that duty caused the damages that subsequently happen. Now there are 2 parts to cause. One is, cause and fact. So saying it actually did cause the damages. The second one is what they call proximate cause. And a lot of courts take this heuristic that is, was it foreseeable? So it's not enough that, this breach of duty caused the damages. It needed to be a breach of duty that caused the damages that would have been foreseeable to the defendant. And then finally, we're going to be talking about damages. So this is, after you realize that there is a breach of the duty that caused the accident or the issue or the damages, now you get into the world of damages to understand what the plaintiff is going to see in consideration for the breach. To illustrate negligence, let's walk through a simple claim here.
Yeah.
A car accident, I think, is probably the most prevalent. So
Perfect.
Let's start there. I'm going to break down a couple facts, and then I'm going to let you show how you build that claim based on the facts.
Okay, great.
So let's say I'm driving, I run a red light, I hit a pedestrian who's walking in the crosswalk, and they broke their leg.
Let's start with duty.
Yep.
You have a general duty to behave in a reasonable manner, conducting yourself in the world.
Yeah, and on top of that, you have a reasonable duty to not injure someone with your car.
And then you have a more specific duty in this context where you have a duty not to run a red light.
Yeah.
And then we have a breach of that duty. Or better yet, you have a duty to stop at a red light.
Yes.
And then we have a breach of that duty where somebody doesn't, in fact, stop at a red light. They don't behave as a reasonable person would, maybe a second breach technically. And that breach causes this accident.
Yeah.
It's the cause in fact, but for them running the red light, this person wouldn't have broken their leg.
They'd still be walking.
And is that foreseeable? What do you think?
Yeah,
It's like, of course, right?
Yeah, 2-ton car running into a pedestrian walking around.
Foreseeable that could break somebody's leg.
Totally.
And then the damages are all of the consequences of that broken leg.
Yep.
Without getting into too much detail here, think all of the medical bills, and then think about all of the consequences that result from a broken leg. Somebody might have a spectacular recovery, and essentially their only damages are the medical bills and the time they had to take off work or whatever. Somebody else might develop bad arthritis and have to deal with this broken leg for the rest of their life. And maybe they used to, love hiking and running marathons, and they now have a hard time doing that. And all of those things would be considered damages.
Yep.
And then the attorneys have to assign some value to that they suggest to a judge or jury who ultimately decides what the damages are.
Got it. So that kind of breaks down the idea of a negligence claim in a very simple fact pattern before we dive into the facts of this case. So in this case, there's an oil company.
Yep.
They didn't cap their drilling site. A school was subsequently built over top of that. And then those chemicals leached from that uncapped oil well, and people developed cancer after, coming into contact with those chemicals, whether, maybe it's in the drinking water, maybe it's just being near it. And so to take a step back, an oil company has a duty when they're drilling and through the use of their wells, not to cause injury to, normal people in their everyday lives, right? Mm-hmm. There is some inherent risk in drilling, but they have the duty to mitigate any risks associated with that. They have the duty to make sure that the drill is capped. The well is capped. And I think in this circumstance, the argument they're clearly making is the duty to not harm the citizenry or the students of the school. And the breach is they didn't take the necessary steps to mitigate the potential harm that could be done by capping the oil well.
Completely agree. And just to place maybe a slightly finer point on the duty here, the duty isn't to erase all possible danger or risk of danger. Yeah. It's to behave in this reasonable manner.
Fair point.
Where your behavior is unnecessarily endangering the public.
Yeah. What would a reasonable person do, right?
Yeah. And so if there is a safer alternative that is, not necessarily free, but a cost effective, safer alternative, then was this reasonable? And the answer is going to be no.
Yeah.
And so, yeah, exactly. To your point, not capping the well whenever there are mechanisms to cap wells where you don't give hundreds of people deadly cancer.
Yes. Yeah, exactly.
It's a breach.
So I think we've gotten duty and breach here. I think a lot of the conversation around this case comes down to cause.
Absolutely agree.
And I actually think the proximate cause, the foreseeability isn't the issue, it's cause and fact. And this often happens with these toxic torts or mass torts claim. For example, just to bring in another example, like Aaron Brockovich, the story that probably everyone has, watched on the silver screen, where the PG&E had leached some chemicals into drinking water. They hadn't taken the necessary precautions, ostensibly. And the question, their argument before they ended up settling was that the leaching of the chemicals didn't cause the actual damages, the cancer that was caused by to the individuals. Similarly here, it's almost like they kind of took that real example and used it in this kind of fictional example.
Yeah, and it's an issue in all kinds of toxic torts. So I think they did a great job capturing the reality of the situation where it's, you might have this hot spot of concentrated cancer diagnoses or, some other issue, but whenever you're talking about population dynamics, it's like lots of people get cancer.
Yes.
For a lot of different reasons. And so was it because of, in the episode, was it because of the power lines?
Yes. Was it the power lines over the house? Or with the lead plaintiff, was his lung cancer caused by the fact that he grew up in a house of smokers?
Yeah.
Or that he was around chemicals in his service of for the country,
his military
service.
I think they said something about burn pits or
exactly. And that's not saying that he wouldn't have maybe a claim against someone else, but they're claiming theirs wasn't the cause of this cancer.
They're saying you got the wrong person. Yes. And better yet, really what they're saying is you're not sure you got the right person.
That's a great point. So in this case, the plaintiff has the obligation to prove each of these four elements: the duty, the breach, the cause, and the damages. And oftentimes, if you're a defense attorney, you're going to argue that they haven't met that burden.
Yeah,
right?
Exactly.
And so in this case, what they're trying to do is create some ambiguity or some maybe a question of whether or not that this leaching of the chemicals was the cause for the cancer. That just creating enough doubt, maybe enough to overcome to the jury the fact that the breach occurred, right? Or that this was the cause of the damages.
Yeah, in a civil lawsuit like this, the standard is going to be preponderance, which is essentially just above 50-50. Yeah. And so the burden isn't especially high by legal standards, but ultimately you have to convince either a judge or more likely a jury of 12 people that this was the cause. And can the defense sow enough doubt? And it becomes this very practical question where you're like, what experts do they bring on to argue that these power lines and cause cancer and they cause these disparate types of cancer?
Well, exactly. And I think the interesting thing, this is an area where there's going to be a lot of science. You're going to have a lot of professionals, expert witnesses come in to help the plaintiffs prove their claim that this was the cause beyond a preponderance of the evidence. And the defense is going to bring on their own experts and say, they don't even need to prove that it was something else. They just need to prove that there's enough doubt that it wasn't this. So they're going to bring an expert witness that says power lines absolutely could cause it. And this is a situation where there are enough power lines in a certain configuration that is very likely to cause certain types of cancer.
And then the plaintiff's attorney is going to cross-examine that expert and say, isn't it true X, Y, and Z? Yeah. And ask them about all of the times that they've testified in cases exactly like this, saying essentially the exact same thing and making lots of money doing it. And so it's like, we have all of these practical dynamics and it becomes ultimately just an issue of credibility and 12 people deciding which story they find more compelling and which story they believe.
So I think under these circumstances, that kind of covers negligence. We'll probably get into negligence in much more detail multiple times over the show, but for now, let's set that aside. I think one of the interesting additional dynamics here is we got a battle of the Titans.
Travis Tanner
versus Harvey, the undefeated duo. And Travis is in there. Travis is in there calling a shot, man. He's like, he walks into Harvey's office and he says, "I want you." And we're introduced to him by, he's maneuvering from the get-go.
Yeah. He's lying about who he is. He's walking into the deposition and handing this file over to the attorney taking the deposition. It's like, this is everything you need in here.
Yeah.
And then
He's very slick.
Lies to Mike, gets Donna away from her desk so that he can then walk into Harvey's office. There's immediately some respect for this guy.
Yeah, Harvey appreciates his
guile.
His guile. I agree with that. Yeah. Although, as we get further into this analysis, we'll realize as well, Harvey questions his ethics.
As he should.
Yes.
As he should. So we have this battle of the Titans, as you said, and we have this split. We have this divide between Harvey and Travis, both very streetwise, very capable attorneys. But at the end of the day, Harvey has these lines he won't cross.
Yeah, and we've seen it over and over again.
Over again.
Yeah, it's the thing that we've fallen in love with about Harvey.
Absolutely. On the other hand, we have Travis Tanner, who has no such lines and is willing to not only break the rules, but repeatedly break the law.
I gotta say, it's the first time that we've seen a defense attorney look like the Antihero, so I'm happy with that.
All for it. We're getting the background on Travis Tanner.
Yeah.
We get some comments about, Mike asking if he wants him to create or read his Wikipedia page, which segues nicely into that Michael Jordan conversation. Harvey happens to have MJ's phone number.
That's it. I mean, would you?
As if we didn't love him enough.
I know, man.
But then we get to know Travis Tanner as this attorney who specializes in breaking class action lawsuits. He said, I think Mike sets this up. He's like, tobacco, pesticide, securities, broke them all.
Yeah. All things that would be fun to defend.
Yeah, exactly. Like really laying it on thick, painting this guy as the villain. Although plenty of lawyers who actually do that.
Yeah, true.
I want to cover two things here.
Let's hear it.
Let's talk about the ethical considerations around talking to a represented party. If
you were to take the letter of the law, you may say, oh, this was super well conceived. And
some of the scenes were very clever. Sometimes he's aggressively just reaching out to the represented parties.
This is actually something that comes up in practice.
Yeah, and so let's talk about two specific situations here as they came up on the episode, reaching out to represented parties.
Yeah.
So we have them going to Kenny Verdasco's house and trying to reach a settlement, going around his lawyer. Clearly illegal and unethical. So there's the American Bar Association puts out these model rules, and model rule 4.2 talks about communication with a person represented by counsel. There are a handful of details here, but the punchline is you can't do it.
You can't do it. Yeah.
If somebody has a lawyer, you have to talk to their lawyer about the matter, at least about the specific matter the lawyer is representing them on.
Yep.
You can't approach them directly.
Which makes sense, right?
Which makes sense. You don't want this kind of behavior where we're seeing on the show going around the lawyer and trying to bully the client.
Bully or manipulate or whatever.
Yeah,
right?
lie to them.
The reason they hired a lawyer is so that they could have a professional to help them negotiate this, issue. Exactly.
So that situation, clearly a violation of the rule. Then we have the situation at the Waldorf where it's a little sneakier, a little bit more clever. Ultimately, we're going to talk about whether or not that breaks the rule.
Yeah, I mean, maybe there are two parts to it. One is he communicated with them to convince them to come. So that one would be a violation, right?
Clear violation, but he said that I think he had some clever response there where he didn't reach out to them, somebody else did, and he happened to be at the Waldorf getting orange juice.
Yeah, sure.
But then once they're there, they're at the Waldorf, a bunch of the plaintiffs have shown up, they responded to this invitation. Travis starts talking to Harvey.
Yeah.
He starts speaking very loudly as though he's only speaking to Harvey.
Yeah.
And all of the clients happen to hear.
Yeah.
And then he ultimately leaves his phone number on the board and says, if you're interested in the settlement, contact me here.
Yeah.
So he's soliciting all of this contact. He's having this contact with represented parties. And then he tries to get around it in this cute way with Harvey there, but he's basically speaking through a microphone. Yeah. And he really indicts himself as being the one who invited them there because he then proceeds to speak to them.
Yes.
To speak indirectly.
To them and give them his
with
number.
air quotes.
Oh, it just happens.
Yeah, exactly.
Yeah.
That wouldn't fly. I'm sure there are situations where people do this in more subtle ways, and maybe even egregiously as this, but this is not a close call. The court would come down on it.
Yeah, it's like too clever by half. He thinks he's getting away with something.
Well said.
Yeah, with something cute, but he's almost certainly going to get caught up in if not a direct violation of the law, like a violation of the spirit of the law. We
have that standard that's being violated here. I think it's something that's really important. And if you do hire a lawyer, you should be very suspicious of an attorney that's willing to reach out to you in spite of that, an attorney on the opposing side, because they know they're breaking a rule and they're willing to do it anyways. So be incredibly suspicious of their motives. Okay, so the second thing I want to talk about as it pertains to Travis is private investigators.
Yep.
So do you want to set up that initial conversation that or better yet, the relationship that Harvey has with this private investigator?
Yeah.
Remind us what's happening there.
We get introduced to a woman, it looks like at a magazine stand, and she's kind of giving him intel on the case. She's giving him intel on, I think on Travis, and I think on the various plaintiffs as well. But effectively, the concept being, look, a lawyer is going to have to figure out facts to prove their case, right? They have the legal elements, and they're going to have to go out there and subpoena people for depositions. They're going to have to request documents from the defendant. They're going to have to go out and research the actual physical setting of the negligence claim, etc. But in order to do all of those things, they may not be the ones, or their associates may not be the ones, or the paralegals may not be the ones to actually go out and do that work. They may not be the best situated to do that work, right? Oftentimes, an attorney is going to hire some sort of private investigator or private investigatory firm, or, some computer specialist, frankly, maybe, to help them unearth the facts that they need for the case.
So I think that's exactly right. And then we also get a bunch of amazing James Bond references.
James Bond wears a suit, Quinn.
We get set up. So we get introduced to the private investigator. They do a great job portraying private investigators as an important part of the discovery process. So we have this more formal discovery, and then we also have this less formal fact-finding, mission that the private investigator goes on.
Yep.
In this episode, we ultimately get to a point where the private investigator records a conversation that Travis Tanner has with the decision makers at the oil company.
Yeah.
Part of that conversation, he says a handful of things, but basically he admits to illegal solicitations from the plaintiffs in this case. Harvey's put in a position where he's forced to make this decision. Is he going to cross this line and play by the rules that Travis Tanner plays by?
Yep.
Or is he going to stick to his own moral principle? And so we're not going to get into all the details of the admissibility of this evidence, but I think the way the show sets it up is directionally right.
Yeah.
Where it's, if he has no idea how he came upon this evidence,
he may be able to get it in.
Might be admissible. If he tapped somebody's phone or hired somebody to tap a phone, probably not coming in.
And even if it did come in, he may have committed a crime.
Absolutely. Yeah. I mean, might even come in for this case, but he loses his legal license. Yes. The judge would have a lot of questions about how we got this evidence. Regardless, the way the show sets it up, he either has to lie and break his own internal ethical code and win the case, or potentially lose the case and stay true to his morals. Insert option 3.
Yeah, exactly.
Harvey finds a way around it. He threatens to introduce the evidence and ultimately doesn't, which I thought was...
It's a bluff.
It's a bluff.
Yeah. And Travis believes the bluff because he would do it.
It's exactly what he would do, which is a bit of a callback to the last episode where Harvey says to Lewis, "That's the problem, Lewis. It's what you would do. So you're so horribly suspicious of everybody else."
Yeah, agreed.
Or at least that's the subtext. And here,
foreshadowing.
It's kind of the same thing where it's like,
nice work.
It's not actually what Harvey would do, but Tanner just assumes everybody's willing to break all rules. And so the bluff works. And I thought it was a fun end.
Yeah, I agree. I think it worked. And I think it would be hard for Harvey to come up with that particular fact, which is incredibly damning, without that conversation. So it gave him a massive amount of leverage, and he went from, I think it was like the offer before that was $25K, and it jumped up to $2 million per person, which is, a great outcome for the plaintiffs, ostensibly.
Yeah. And so I want to kind of rapid fire run through a few different legal issues. One, the $2 million per plaintiff, that makes more sense in a class action setting where, they were harmed in the same way and they received the same payout.
Yep.
We already mentioned it, probably not the way this would actually play out. So $2 million might be a windfall for somebody who had a very treatable cancer that didn't impact their life in any, very, very minimally.
Yes.
And then might be massively undercompensating somebody who has literally millions of dollars in medical bills from the cancer, not to mention that their life was destroyed.
Agreed.
Thought it was worth mentioning, while it's a huge number, vary from plaintiff to plaintiff, and one of the primary reasons this would be brought as mass tort claim.
Agreed.
Now, they talk about they got to this $2 million and this much bigger outcome, this bigger win for the plaintiffs, because Harvey funded the litigation.
Yeah.
He put up enough money to give, I think, what did it shake out to be? I think it was $1 million.
I think he funded $1 million. So he takes out $1 million to take the immediate payout, the pressure of an immediate payout off the table for the various plaintiffs.
Yeah. And so you see litigation finance serving this role and other roles in litigation, both funding the legal fees and the expert witness fees, but also potentially as an advance on the future payout, because these plaintiffs are dealing with real cost as a result of this. Medical bills are starting to accrue, et cetera.
Yeah, and it's going to take potentially months, if not years, to resolve and receive some kind of payout. And that's some real financial pressure that they may be under during that interim period, which a defendant could use against them.
And so, setting aside any rules related to loaning your clients money, et cetera, there is this mechanism by which you could potentially take out a loan on litigation, and it's this industry known as litigation finance.
Yeah, exactly.
I'm sure we'll get into that in some future episode in more detail. But yeah, so I think that hits most of the legal points.
This was a legal heavy episode, and I think that kind of covers most of the legal points.
Yeah, I'd be curious to get some questions in the comments, things that we could maybe address in future episodes or just quickly respond to down in the comments section.
Yeah, if you have anything that you thought, oh, that spurs another question, let us know. We'd be happy to
drop it down in the comments, and we'll get in there and respond. But yeah, I guess taking a quick step back before we wrap up, what'd you think of this episode?
I thought it was good. It was fun to see Harvey on the plaintiff's side. It was fun to see, for the first time, see him against an equal adversary, as we would say. He was a little nervous. It was the first time I'd seen him shaking in his boots a little bit. Yeah,
it was fun. I really enjoyed that part of it too. They set up that rivalry in a great way. And I thought the writing on this episode was fantastic.
Ooh, tell me more.
I mean, at this point, I'm just parroting what you said, but it's really cool to see Harvey as a plaintiff. It's fun to see him fighting for these people that got screwed over by an oil company.
Yeah, I mean, he's a big corporate lawyer. The question is, does this change the course of his various claims that he takes on? Is he earning a bleeding heart right now?
We're about to find out.
I know. I'm excited to hear.
So that wraps up episode 9 of Suits on Suits. This has been fun.
Yeah, we're 3/4 of the way through the first season. So, we're learning as we're going through this, and I hope this is interesting to you guys. It's been a lot of fun for us. So stay tuned for the continued development of Suits on Suits.
Yeah, please do. And go ahead and subscribe, like, and maybe most importantly, leave some comments and let us know what you'd like to see more of. Or if you have any questions, like we said earlier, we'd love to jump in there and engage with questions.
Awesome.
All right. We'll see you next week.